Mr. Vice President, Honorable Justices, Rule 50, subparagraph 2D of the rules of this court provide that an application will not be admissible where it is based exclusively on news disseminated through the mass media. This requirement is also set out in and based on Article 56, subparagraph 4 of the African Charter, which the court is required to have regard to. As Rwanda emphasized in its written submissions at paragraph 94 of the rejoinder, the purpose of this rule is to avoid applications based on allegations brought without any verification of their veracity. Right. This limb of admissibility appears to have received little attention in this court's jurisdiction in comparison with other grounds of admissibility. Now, it may be for this reason that the applicant chose to completely ignore its reply submissions. We don't know. But what we do know is that this is a stated and express requirement for the admissibility of an application to this court, and one which must be applied. In this case, is that the application that is brought against it, and I emphasize that for reasons I'll come on to, is based exclusively on news disseminated through mass media. Please allow me to explain. You will note that the application that is brought by the DRC is not brought generally on the situation in the Eastern DRC. It is an application which alleges that Rwanda is responsible for the violation of human rights, either directly as a result of acts allegedly perpetrated by its armed forces, or allegedly by providing support to the M23. That can be seen on the face of the application as filed itself, on pages 4 and 5. Accordingly, when this honorable court is assessing whether the application is based exclusively on news disseminated through the mass media, there are 2 points which are relevant. First, the court must assess whether the case which is brought against Rwanda, that particular case, is based exclusively on news disseminated through the mass media. Thus, other material which merely go to other extraneous matters or simply address the situation in the Eastern DRC, but do not go to the very case that is brought against the respondent itself, we submit, cannot be taken into account when examining this issue. Second, the court must evidently consider the matters which were filed in support of the application, and is therefore necessarily restricted to the materials which existed at the time of the application and which were relied on by the applicant when making the application. Mr. Vice President, Honorable Justices, the material relied upon in the application against Rwanda is derived entirely, we submit, from media sources. As we submit at paragraph 74 of our preliminary objections, the term mass media, as used in Rule 50, subparagraph 2D of would necessarily be understood to mean material primarily based on or disseminated through media reports, its source notwithstanding. Mr. Vice President, Honorable Justices, as I submitted earlier, there is, in comparison to other grounds of admissibility, little jurisprudence on this point. But we do have some guidance from what does exist. So, for example, in Communication 245/02, which was the case of the Zimbabwe Human Rights NGO Forum against Zimbabwe, the Commission, after reviewing the document submitted by the complainant in that case, found that the case was admissible because the material before the court contained statements made by the victims themselves and included a decision of the High Court of Zimbabwe on the issue. So that was which the court found that the matter was admissible. Second, in the case of Frank David Omari and others and the Republic of Tanzania, before this court, the applicant in that case was recorded at paragraph 96 of the judgment, submitted details, including the names of the persons who were said to be victims and details of their hospitalization. So the newspaper excerpts which were introduced in that case were only in support of the allegations which had been made and the information provided on behalf of the victims themselves. And that was the basis on which the case was found to be admissible. In the present case, however, the application against Rwanda is based exclusively on news which has been disseminated through mass media. The only sources which seek to implicate Rwanda are news reports. In this regard, I note that some of this material are from questionable online sources, which we submit are of no probative value before this court. And I note, for example, in that regard, numbers 3 and 70 of the alphabetical list of documents which were submitted with the application. Mr. Vice President, Honorable Justices, there is, of course, another group of materials relied on by the applicant, which are from UN bodies or are communiques from regional bodies. However, all of those documents address the general situation in the Eastern DRC. They do not address or support the application that is presently before you against the Republic of Rwanda. As we stated at paragraph 74.2 of Rwanda's preliminary objections, which the applicant chose not to respond to, the non-media documents which have been submitted do not evidence the attribution of any act or conduct to the respondent. Accordingly, to the extent that the applicant cites those other materials, we say that they have nothing to do with the case they have brought against Rwanda. The applicant cannot cure the obvious deficiency in its application by citing material that is not directly relevant to the application before the court. It is quite simply, we submit, an attempt to circumvent the clear admissibility requirement of this court and should not be encouraged. The applicant cannot point to any relevant material on which the application against Rwanda was based, besides news materials, press statements from its own armed forces, which we say are evidently designed for the media, and other materials from organizations which are solely disseminated through the mass media. And that is why we submit that the application that is brought against Rwanda is based exclusively on news disseminated through the mass media and should therefore be held inadmissible. If the approach taken by the applicant is permitted, this will mean that parties before the court can base the applications exclusively on news based from mass media in contravention of the clear requirement, and then include some other sources which are not directly relevant, but then point to that to say, oh, look, this means it's not exclusively based on mass media. That cannot be. In Rwanda's submission, this will make a mockery of the admissibility requirement, which was clearly inserted for a purpose. Mr. Vice President, honorable members of this court, as I come close to my submissions, it is also noteworthy that during yesterday's hearing, counsel for the applicant stated that the applicant has massive evidence of Rwanda's alleged crimes in the Eastern DRC, and that they will avail this evidence at the opportune time. We submit that this is confirmation that at the time of filing this application, the applicant simply relied on those mass media sources. The courts will recall that Article 6.2 of the Protocol and 56 of the African Charter are emphatic that whatever evidence an applicant seeks to found the application on must be presented to the court at the time of filing. One cannot approach the court, we respectfully submit, with an assortment of material from mass media in order to seize the court and then subsequently gather information in support of that case. That is an inappropriate use of this court's resources, and we submit should not be permitted. Mr. Vice President, honorable justices, that concludes this part of Rwanda's submissions on the questions of admissibility. And unless I may be of further assistance, I invite the court to give the floor to Dr. Owiso to continue with the last round of admissibility.
Mr. Vice President, I would like to address the court on a final ground of admissibility, being abuse of process. But before I do that, permit me to correct the record slightly. I indicated earlier, when addressing the question on local remedies, that the provisions of the Constitution of Rwanda that make human rights treaties directly justiciable were Articles 95 and 196. The correct or the proper position should be Article 95 and 169. Thank you. Now, finally, I address the court on abuse of process. Mr. Vice President, honorable justices, allow me to recall the common maxim: whoever comes to equity must come with clean hands. The DRC has not come to the court with clean hands, and this application should therefore not be entertained. Immediately after filing this application, the DRC filed substantially the same application before the East African Court of Justice, that being reference number 33 of 2023. Mr. Vice President, honorable justices, you will note that, like this application before this court, the reference before the East African Court of Justice was also the first interstate case before that court. That, we believe, is relevant information. The DRC did not disclose its intention to the court when it filed this application, and when it also filed its additional application a month later, as is perhaps expected of a party that is intent on getting a tactical advantage by leveraging whatever remedies it can get from more than one court. Once Rwanda exposed this duplicity in our preliminary objections, all the DRC could offer in response was a feeble denial of the similarity between the two cases, and also a rather puzzling denial of the East African Court of Justice's status and identity as an international court, and a further denial of that court's jurisdiction. As regards the similarities in both cases, Mr. President, Honorable Justices, we have taken the liberty of fleshing them out for the benefit of the court in paragraphs 92 to 102 of our preliminary objections. Further, we have produced the original ESCJ reference and the amended ESCJ reference, those being Annex 4 and Annex 1, respectively, in our rejoinder. A plain reading, therefore, reveals the obvious identical nature of the ESCJ reference and of the application before this court, being that they involve the same parties, being the DRC and the Republic of Rwanda. They involve the same course of action, and the same remedies are sought in both the East African Court of Justice reference and in the application before this court. We are confident that this will be obvious to the court when it reads the ESCJ reference as against the application before the court. No useful purpose is therefore served by belaboring that point. As regards the DRC's claim, in paragraphs 292 to 298 of its reply brief, that the East African Court of Justice and this court are not of the same legal order, it is not entirely clear to us what the DRC means by this, particularly in view of the rather obvious fact that both these courts are international courts established by multilateral treaties concluded by several African states, including the Democratic Republic of the Congo and the Republic of Rwanda. We also invite the court to note that the African Commission has found in Communication 339/2007, being Patrick Okiring and Agipos Samson versus the Republic of Uganda, at paragraph 69 of that decision, that the ESCJ is a regional judicial mechanism which is capable of granting declaratory or compensatory relief, and that it is therefore one of the mechanisms envisioned under Article 56, paragraph 7 of the African Charter, which the court will note is the same in the same terms, my apologies, as Rule 50, paragraph 2G of the court's rules. Indeed, we do not require the pronouncement of a judicial or quasi-judicial mechanism to the effect that the East African Court of Justice is an international court. That point is rather too obvious. Accordingly, any suggestion that the ESCJ is of a different order, whatever that may mean, is not correct, and it does not negate the relevant principle before this court. As regards the DRC's claim in paragraphs 279, 278, and 295 of its reply brief that the ESCJ does not have jurisdiction to adjudicate over claims of a human rights nature, we find this truly puzzling for at least 3 reasons, which I will presently address. First, as early as 2007, in its judgment in James Katabazi and 21 others, versus the Secretary General of the East African Community and the Attorney General of the Republic of Uganda, that is reference 1 of 2007, the East African Court of Justice asserted that since the East African Community Treaty has, and I quote, hints of human rights, end quote, in its provisions, alongside its primary jurisdiction of interpreting and applying the EAC Treaty, it can address human rights violations raised in a course of action flowing from the East African Community Treaty. Rwanda's contention, Mr. Vice President, honorable justices, is not that the ESCJ's primarily exercises human rights jurisdiction, my apologies. Rather, that is not our contention. Rather, our contention is that while the ESCJ's primary jurisdiction is the interpretation and application of the ESC Treaty, the court has in fact interpreted this jurisdiction to include examining issues of human rights violations in a cause of action flowing from the ESC Treaty and granting appropriate relief. The ESCJ's jurisprudence since the Katabazi decision, which I just referred to, has been consistent on this point. And it has indeed subsequently adjudicated allegations of human rights violations and pronounced itself on human rights issues in several cases. Just to highlight a few, one being the Attorney General of the Republic of Kenya versus the Independent Medical Legal Unit, the Attorney General of the Republic of Rwanda versus Plaxida Rugumba, and the Attorney General of the Republic of Uganda versus Tom Chahurenda. Mr. Vice President, honorable justices, you will note that these decisions were made by both the First Instance Division and the Appeals Division. So both chambers of the ESCJ have similarly concluded, and that matter is now quite tried before that court. Regardless of what opinion one may have regarding the ESCJ's interpretation of its own mandate, it is indeed now a notorious fact that that court can adjudicate over human rights issues, which fact the DRC is very well aware of, and of which we respectfully submit the court ought to take judicial notice. Second, in reference number 33 of 2023, pending before the East African Court of Justice, the DRC has indeed invoked substantially the same allegations of human rights violations as in the application currently before this court, ostensibly with the belief that the ESCJ can indeed adjudicate over these matters. The ESCJ reference raises mixed and inextricably linked issues which the DRC alleges flow from the ESC Treaty, those being peace, security, sovereignty, territorial integrity, and human rights violations arising from the former issues. In line with the ESCJ's consistent jurisprudence, as I've just highlighted, that court's mandate covers all the issues raised in that reference. Mr. Vice President, honorable justices, the court will note that as of today, the DRC is still aggressively prosecuting its case before the East African Court of Justice. Why then the DRC would consciously request the ESCJ to adjudicate upon alleged violations of human rights and yet later turn around to disown that court's jurisdiction over those matters before this court is beyond our comprehension. As is evident from our written and oral submissions, Rwanda is, of course, aware that the ESCJ, that is the East African Court of Justice, has not yet decided the case brought by the DRC. We do not shy away from that. We do, however, make the following points. First, it is plain that the proceedings before the East African Court of Justice are at a more advanced stage than the application currently before this court. The ESCJ held a hearing on preliminary objections on the 26th of September 2024, and a ruling is expected any day soon, any day now, my apologies. It is therefore more likely than not that should this case proceed to the merits phase, the ESCJ may render a decision on the reference which will certainly answer similar questions to those raised in the application before this Honorable Court, before a decision from this Court on the merits. In those circumstances, Mr. Vice President, Honorable Justices, it would be pointless to have to come before this Court in the future to submit that the matter has been settled as the ESCJ has rendered its decision on the case. A significant amount of resources, both on the part of the parties and the Honorable Court, will already have been expended by that time. It would equally be inappropriate for there to be, or for there to be perceived to be, a race between two regional judicial institutions, being the ESCJ and this Honorable Court, as to who gets to a judgment first. Second, what the applicant has engaged in is essentially a case of forum shopping, which we respectfully submit should not be encouraged. By bringing claims against Rwanda in multiple fora, the applicant is intentionally contravening the well-established principle of non bis in idem, whereby a state may not be sued or condemned more than once for the same alleged human rights violations. The Court must, we respectfully submit, also consider the effect of the ESCJ rendering a judgment while these proceedings before this Court are pending. If, for example, a decision is rendered by the ESCJ which is favorable to the applicant may then take the view that it does not wish to proceed in the present proceedings, leading to a significant waste of resources and an embarrassment to this Honorable Court. This is precisely why forum shopping should not be encouraged. Mr. Vice President, Honorable Justices, that is not the only problem with the applicant's approach. There is also the risk of conflicting decisions and or remedies from the two reputable international courts in the African region on what is, on the applicant's case, not only a politically sensitive matter, but one that it alleges involves multiple human rights violations. It is needless to point out the problems that this will create. They are rather obvious. It is in the interest of all parties, and indeed all concerned in the region, including any alleged victims and or survivors, that whatever judicial resolution is obtained is clear, is unambiguous, and is unimpeachable. This cannot be achieved where there are two conflicting decisions from two international courts on the African continent. It cannot be achieved where one court makes orders which are implemented by those involved, and then in a different court provides conflicting orders months down the line. Mr. Vice President, Honorable Justices, this is the first time since the court started operating that it is faced with such an obvious abuse of process, whereby the DRC is clearly setting this honorable court on a collision course with its sister court, the East African Court of Justice, and thereby exposing this court to significant judicial embarrassment. If this practice is not prevented through a ruling of inadmissibility, the very authority of this court, we fear, will be in jeopardy. Rwanda submits that it is important that the integrity of this court be protected at all costs. Similarly, as an integral part of the international dispute settlement system, the court has a duty to protect and safeguard the integrity of the international legal system. This court ought to do that by refusing to let its processes be abused by the DRC and by declaring the application inadmissible on account of this obvious abuse of process. Rwanda emphasizes that this abuse of process is sufficient ground for the court to declare the application inadmissible. And we pray that the court does so. Strictly, in the alternative, should the court be hesitant to find the application inadmissible and dismiss it, we submit that the court has inherent powers to order a stay of proceedings pending hearing and determination of the reference before the East African Court of Justice. And we do make this, I emphasize, strictly in the alternative. Our primary submission being that the abuse of process is itself sufficient to declare this inadmissible and dismiss it. This is a fairly common practice in international adjudication, Mr. Vice President, Honorable Justices. For instance, the arbitral tribunal in the Mox plant case between Ireland and the United Kingdom, in its order number 3 of 24 June 2023, suspended proceedings in order to await the outcome of parallel proceedings before the European Court of Justice. Closer to home, in 2012, a Community Court of Justice of the Economic Community of West African States, ECOWAS Court, in other words, suspended proceedings in Laurent Simon and Michel Gbagbo versus the Republic of Côte d'Ivoire and Alassane Ouattara, pending the outcome of proceedings at the International Criminal Court. The African Commission also indefinitely suspended proceedings in the case of Inter-Rights on behalf of Pan-African Movement and Citizens for Peace in Eritrea versus Ethiopia. That was suspended pending the outcome of proceedings before the Ethiopian Eritrean Claims Commission. We highlight these examples to show the court that this is not alien practice. So, Vice President, Honorable Justices, with that, we come to the end of our submissions on admissibility. Permit me to conclude by restating our position in the preliminary objection that 1, the application is incompatible with the Constitutive Act of the African Union. 2, that the applicant has failed to exhaust local remedies. And 3, that the applicant has failed to fulfill mandatory treaty preconditions. 4, that the applicant has failed to pursue and exhaust international procedures of settlement or good offices. 5, that the application is based primarily on news disseminated through the mass media. And lastly, that the application is an abuse of process. Consequently, the Republic of Rwanda implores the court to find and declare that the application is inadmissible. And as a final note, in the interest of plurality of language, allow me to thank you in Swahili. Makamu wa Rais wa Mahakama, majaji wa Mahakama, asanteni sana kwa umakini wenu.
Est-ce que l'État défendra autre chose à ajouter, étant entendu qu'il vous reste encore 8 minutes? Très bien. À présent, nous ordonnons une suspension de 10 minutes avant de reprendre l'audience.
Yes. 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 Well, okay. Ili anini apate nafasi, tunataka nafasi. Sawa, hapo si anapata nafasi.
Check 1, 2.
Yes. Testing. 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 Yes. 1, 2. 1, 2.
Check 1, 2. Microphone testing. Check 1, 2.
Specific circumstances that will neutralize the implementation of the exhaustion of remedies. In its order of 7th of March 2024 relating to the accelerated procedure formulated by the DRC, your court recognizes the complex nature of this nature, especially when it considers, and I quote, that this conflict could have caused human losses, rapes, destruction of very wide damages, entailing to a complexity of this case. Honorable Shafika Ben Saoula, who is with us, in the case Loco against Burkina Faso, has recently underlined in her declaration the importance for the court to take into account the complexity of the matter in order to eliminate or neutralize the implementation of this rule, Article 8 of her declaration of the 3rd December 2024. Mr. President, Honorable judges, yesterday Professor Alphonse Mutuba, in his intervention regarding the factual context of this dispute, has underlined with many details the magnitude of human rights violation committed in the territories occupied by the Rwandan forces and the M23. We have to add to this the continuous nature of massive and grave violation of human rights against populations who are living in occupied areas. The continued occupation of some conflict area by the coalition of the Rwandan forces and M23 indicate that murders, rapes, and stealings or other violation of human rights and forced displacement of civil population continue to happen. Populations are being displaced and live in camps which have been prepared for this occasion. On the other hand, the behavior of Rwanda is neutralizing the resort to this rule of exhaustion of remedies, supporting the armed groups and intervening directly in the Congolese land without in full impunity is contradictory to this their arguments, and they should indeed relieve the Congolese victims and stop such actions. Mr. President, honorable justices, my second argument, which is relating to the inefficiency of these cases. According to the jurisprudence, in the implementation of the rule of exhaustion of remedies, 3 fundamental criteria should be taken into account. From the other part of the bar, they insisted only on 1 criteria. The 3 criteria are the availability, the efficiency, and the satisfaction. So our team has talked about these 3 criteria. In the responding state have tried to demonstrate these 3 criteria. A remedy is considered as being available when it can be exercised freely without obstacle. In the case Zita against Mozambique in 2011, the African Commission on Human Rights and People says, I quote,
also in practice, failing which it will lack the requisite accessibility and effectiveness. Le requérant soutient ici, Monsieur le Président, honorable juge,
underlining here that these remedies are not available. Indeed, in a conflictual violence context entertained by Rwanda on the Congolese land is requiring the victims to exhaust local remedies based on a reasoning which is not connected to realities, in conformity with the two cases raised by the responding state, where crimes were committed in abroad were judged by the Rwandan courts, and but they have been committed by the army of the respondent state, also in spite of proofs and evidence existing in the file. So we should not indicate that there are remedies existing for facts they deny. No victim can reasonably seize jurisdiction of a state which forces are occupying its land, and then we wonder who is going to do that. In occupied land, some people are arrested, and the civil society organizations are even suspended from their activities. So how can they exhaust local remedies? Mr. President, distinguished judges, honorable judges, the court reaffirmed that it is not enough that a remedy exists to satisfy with to the rule of exhaustion of local remedies. So such remedies should be efficient, relevant, and this is, for example, what is shown in the case against Benin, as I said it. So the remedies should be able to remedy to the grievances and have at least a success outcome. If the court has to conclude that such remedies exist or are available, you should see, however, that they cannot remedy to the situation, to this grave situation. On the other hand, this violation go within a context of an illegal situation on the territory of the applicant state. In the communication 220, DRC versus Rwanda and Burundi, the African Commission has admitted the responsibility of the applicant for similar acts that are ongoing today. The African Commission of the Human and People's Rights, through this communication, has indicated that no investigation was opened and there was no prosecution. In the case Aktivar versus Turkey, the European Court, in paragraph 68, deemed that some specific circumstances can prevent an applicant from exhausting local remedies. And this, for example, the total passivity of national authorities facing very serious allegations, according to which agents of the state have committed errors that have caused prejudice, for example, when they do not start an investigation, for example, as I have just mentioned. On the contrary, the respondent state is denying any such a case. For example, in the case against Mauritania, the African Court decided rightly that if there is no prosecution, then the remedy are not efficient. This is what has been demonstrated. On the other hand, the DRC has launched international arrest warrants against people who have committed crimes similar to these ones and who are on the Rwandan territory without obtaining any favorable reaction. Some citizens and nationals are Inosi Orinda, Eric, Jean-Barry, Bundori. These are Congolese citizens who are being prosecuted on Rwanda, and the criminals have not been prosecuted. Also, they didn't offer to prosecute them, and even they did not deport them to Congo. So you have to take into account this political and legal factual situation to judge on this insufficient application or an objection, especially taking into account the Tanzanian case. Allow me, Mr. Vice President, to develop my third argument on the inapplicability of the protection. So Rwanda has founded itself on the exhaustion of local remedy on the basis that the request of the DRC is a diplomatic case. But it changed its mind, and this time it argued that there are some similar cases that will justify this case by analogy, but it is difficult for them to defend it. Why? First, as we said it in our submission, the diplomatic protection doesn't apply in this case because it means that there is a situation where human rights violations have been committed abroad, while in this case the factual facts object of this application happened on the land, the DRC land. Also, all the we have the case of 1998, and its Article 38 confirms what I've just said. Now, regarding the protection of a state in favor of its citizen abroad is also confirmed in cases of reparations of damages, and like, for example, Ethan van der Switzerland against the United States, and so on and so forth. In addition to the comments of the International Court regarding the diplomatic protection, page 25, paragraph 4. Second, the jurisprudence of the African Commission in the case 240 DRC Rwanda Burundi confirms the irrelevance of the argument about the diplomatic protection, which Rwanda tries to establish based on the principles governing the diplomatic protection. In this case, the Commission did not refer to the diplomatic protection, but rather deemed, and I quote, violation object of this case have been perpetrated in the land of the state. 3. The position of the European Court of Human Rights in the case Ukraine and Netherlands against Russia we are referring to should be quoted in their entirety, because this court doesn't discard the possibility to derogate and to waive to the rule of applied in the interstate affairs and matters, and also the possibility to waive from the exhaustion of local remedies in interstate matters when one part denounces an administrative case. According to the European Court, in this case, and I quote, it is the repetition of the acts which have been possible because of the inaction of the authorities which lead to conclude that the local remedies are not enough to prevent that such acts are repeated.
Massive violation committed by the RDF in a repeated manner in the case cited by the respondent state, the European Court take into account in paragraph 896 the high number of violations to determine that there is a system in the various acts undertaken making it possible to establish a pattern. Vice President, judges, I'm going to conclude on why it is not possible to exhaust internal remedies. The African Charter and a protocol establishing the court excludes the application of the rule of exhaustion of local remedies in a situation where the defender is misinterpreting the provisions establishing the court and the relevant provisions of the Charter and the rule. Article 50 of the Charter says the court will examine admissibility of a case brought before in relation to Article 56 of the Charter and 6.2 of the Protocol. Article 56.1 of the African Charter provides that the communications referred to matters relating to human rights should necessarily fulfill the conditions. In Article 55, it provides before each session the court will list the that said, a combined reading of Article 56.1 and 55 excludes interstate application. Article 56, the formulation other than those of state parties does not leave any ambiguity, because Article 1 of 56 relate to interstate applications different from those referred to in Article 55, saying that actors other than state party are concerned. Secondly, Rule 40 of the court are not autonomous requirements when it comes to exhaustion of internal remedies, as the respondent state has said. These rules are autonomous requirements when it comes to exhaustion because they are based on an isolated interpretation of the rule, which constitutes a right without taking into account the primary instruments of the court. Thirdly, and to conclude, the argument advanced by the respondent state in paragraph 148 in its pleadings, in a case where a commission versus a state, most of the cases brought before the case to justify makes the article devoid of any mission. The practice demonstrates the opposite. Most African states bringing cases before the court or commission, and the African court has received 325 from individuals and 22 from NGOs, and all these lead to the conclusion that the case referred to in 25 is those between individuals and NGOs, individuals or an NGO to a state, because these are the most frequent cases brought before the commission as well as before the court, contrary to the assertions made by the respondent state. Honorable President, honorable judges, taking all this into account, we invite the court to say that the diplomatic protection does not apply, and also the exhaustion of local remedies does not apply. Thank you for your kind attention, and I invite you to give the floor to Professor Lumumbaya. Honorable Vice President, honorable members of the bench, it is a renewed honor for me to take the floor before your eminent jurisdiction as part of the ongoing proceedings. I'll address the exhaustion of international and regional remedies in order to avoid facing up to its responsibilities of violation of human rights in the DRC. Rwanda has come up with a number of arguments, and in truth, these are pretexts to argue that the present case is inadmissible. They have they have cited a rule in relation to non-exhaustion of international regional remedies. This has been swept aside by my colleague Tresor Moindo, who took the floor before me. So I'll not go back to that. In Rwanda, also made reference to two pretexts. First of all, Rwanda expect to obtain from your court the inadmissibility of the application of the DRC on the grounds that the applicant ought to have and didn't exhaust international and regional remedies available to it. Secondly, that DRC did not respect the preliminary requirements, did not respect the preliminary non-judicial procedures required. I'll methodologically to counter these arguments brought before you. Honorable Vice President, honorable judges, the alleged non-exhaustion of international regional remedies is not a requirement nor a legal obligation for the admissibility of the application of the Democratic Republic of Congo in the instant case. Indeed, let me recall that we are here having before us a confusion orchestrated by the Rwanda relating to the remedies provided for in Article 50 of the Charter and an alleged exhaustion of international regional remedies, which according to them flows from traditional rules as well as diplomatic protection which they brought forward against the arguments of DRC. Rwanda finally admitted that this is not a context of diplomatic protection where the rule of internal exhaustion of internal remedies would apply. My predecessor brought up arguments to this to show that the limitations of the arguments relating to the exhaustion of local remedies. In an event, probably in a miraculous manner, that this rule will be accepted by the court, Rwanda does not indicate any reference, does not give any reference that will which will serve as a basis in relation to the international regional remedies, and they do not indicate any procedures, any relevant procedures. In Rwanda, therefore, limited itself to a citation of previous practices in relation to the Vienna Convention, the right of treaties, and to conflate it to the exhaustion of international regional remedies in Article 50 of the Charter. Honorable Vice President, honorable judges, the learned professor on the other side said that this is the practice between practices, whereas it was necessary to identify the alleged practice which is applicable, and then we need to verify if the DRC considers this to be an applicable rule, and in any event the DRC objects to this. Using this malicious intellectual gymnastic, Rwanda is trying to give a wider scope to this article of the Charter. The African Commission on Human and People's Rights, which is not the same as the rules of this court, let me point out, Honorable Vice President, honorable judges, to what extent Rwanda is allergic to the Commission when they say things that, when the Commission says things that are not in their interests. Either the problem is that there as well, the reasoning of Rwanda has legal problems. Normally, they talk about the what can be gleaned from the decisions of the Commission. How then can they reject some of the decisions of the same Commission when it does not favor them? Now they come to appeal to your jurisdiction, the application of the rules of court of the same Commission, whereas the court has its own rules of court, which logically should take precedence in our situation for purposes of relevance and accuracy on the issues before us. Honorable Vice President, honorable judges, in any event, it is based on their reasoning that Rwanda is claiming that DRC should have attempted negotiations in relation to the alleged conflict or sought the good offices of the UN before coming before you. And they are saying that when you examine the examination of the context of the African Charter, support this conclusion because all interstate procedures will require a prior dialogue between the states involved in pursuance to Article 44, and give them time of reflection to arrive at a mutually satisfactory solution, which is not absolute. The DRC would like to point out that the internal remedies provided for in Article 50 of the Charter relate only to the framework of diplomatic protection, which unfortunately for the respondent state is not the object of the instant case. We can never overemphasize the fact that the rule of exhaustion of internal remedies which Rwanda is attached to does not apply here. It's not relevant here. And in a matter between the two parties before the Commission in 2003, and here I believe that Rwanda is not going to deride the relevance of this case that I'm citing in support of the rules. It said that when the acts underpinning the alleged violation of human rights occurred on the territory of the applicant state, there's no issue of exhaustion of internal remedies, and that this does not apply. Similarly, as your court has already asserted this in Alibi Igame versus Tanzania, no prior procedure is required in such circumstances. When DRC decided to come before your court, no valid legal reasons requires it to go through any prior procedure before coming before you. Further, Rwanda's attempt to extend the scope of application of Article 55 through the interpretation of Article 102 of the Rules of Court of the Court creates further problems. Apart from being inaccurate in international law, it is not well grounded. First of all, because Rwanda raises this objection before your court on the basis of a rule applicable before the Commission. In the rules of that Commission, Rule 109, which is the basis for going before the Commission and not before your court, and looking at things closely in point 2b, the rule provides that the communication should contain information on the following elements to be accompanied: B, measures taken to exhaust regional or international to resolve the matter. Honorable Vice President, your honorable judges, such a provision cannot be relied on before your court, where auxiliary measures of exhaustion of the measures before it, and this is not one of the requirements. Further, given the fact that the court's rules of court in its 2010-2020 versions did not make any such requirement extending the Article 50 of the Charter, there's then nothing to make such a suggestion. According to Rwanda, the absence of the requirements of Article 50 of the Charter suggests that the remedies to be exhausted will also include international regional remedies. Rwanda is also trying to mislead the court in relation to Rule 109B of the Rules of the Court, which makes specific reference to regional or international remedies and not remedies in general. As they claim, and wrongly so, such a manipulation cannot be tolerated by your court and should be dismissed with all the consequences that flow from it for Rwanda. Given the fact that this is not a conflict in the classical term of the sense, there's no reason for the Democratic Republic of Congo to have recourse to the said international regional remedies that Rwanda is making reference to, Article 46, 47, by conflating it with other requirements. DRC would like to clarify that the procedures provided for in Article 47, 48 of the Charter are the basis of measures to be exercised, and they provide as follows. If a state signatory to the Charter violates the provisions, it could, through a written communication, draw the attention of the state to the attention. This is Article 47. If within a period of 3 months from the date of reception of the original communication, the issue is not resolved to the satisfaction of the two states involved through negotiation, bilateral procedures, one or the other will be entitled to submit the matter to the Commission through a communication addressed to a corresponding address to its president and to other instances of the African Union. That is Article 56. DRC points out that Rwanda deliberately avoid mentioning Article 49, which specifies clearly that in spite, notwithstanding the provisions of Article 47, if a state party to this party and another state also party to it may directly address a communication to its president, Secretary General of the AU, and to the state involved. All these provisions of the Charter establish the establishment of a truth, that is the latitude or the possibility to negotiate, which is a possibility given to all states party to the Charter. If they find it necessary, it is neither an obligation nor a precondition to be satisfied before coming before your court. As the court may observe, Article 48 is permissive and not mandatory. We agree with our colleagues on the other side. Just as they can come directly before the court, in one or the other case, the Article 48, provisions of Article 48 will have to be respected. DRC has decided to come directly before the court because it believes that Rwanda has violated and continues to violate human rights protected by the Charter and other relevant instruments in relation to human rights. How then can we imagine that while on the field human rights are being violated, human rights are being overlooked, entire ethnic groups are targeted by military groups? How then do we start with negotiations with a state that has genocidal intentions? Article 49 of the Charter, overlooked by Rwanda, makes mention to this possibility granted to DRC. The court will observe that Rwanda does not counter the arguments of DRC on this permissive and non-mandatory of Article 47 of the Charter. It would be improper to interpret the Charter not in its totality but based on specific provisions. Honorable Vice President, honorable judges, with your indulgence, I would like to move on to my next argument. as a precondition among these preliminary procedures. Rwanda claims that Rwanda did not exhaust procedures enabling it to resolve the conflict through investigation, and that it ought to have followed the mandatory preliminary procedure prescribed by the African Union. Rwanda claims that the matter is based on political issues of peace and security, which is wrong, and claims that the RC should have gone through these preconditions. The obligation to respect the procedural measures provided in Articles 28-29 of the Great Lake Pact cannot be applied to this case. The procedure prescribed in those provisions do not really apply to the African Court, which is a specialized court on human rights, as we said yesterday. It relates to the general mechanisms, general justice mechanisms within the African Union. So that procedure is applicable when there's a conflict requiring the interpretation and application of the Charter. Rwanda went as far as claiming that human rights violations for which there is perfect reasons to believe that they are the authors are political issues relating to security, and that there is nothing relating to human rights violations. And then they go on to suggest a procedure provided for in Article 29 of the Pact. Given the applicable laws, it looks like they want to constitute an obstacle to the work of the court. They have the vain attempt to characterize their activities differently is to divert the jurisdiction of the court. Let's assume that the RC failed to comply with the preliminary procedures. Rwanda recognizes that the court they are referring to is not a court of the African Union, and this court will therefore does not have to respect the requirements of another court. We are here before a confusion which is in the imagination of Rwanda when they need to overlook the truth. And this is due to a misunderstanding of the African Union Charter. The court will therefore not show any indulgence to those who out of bad faith are trying to. It will be wrong for them to bring this argument before this court. DRC therefore invites the court to dismiss this argument. It is on. It is here. I like to conclude my submissions, Honorable Vice President, Honorable Judges, and I thank you for your kind attention and request you to give the floor to Lawyer Jean-Paul Mwanza to continue with the plea of the Democratic Republic of Congo.
Honorable Vice President, Honorable Justices, I would like to thank you for giving me the floor to continue the plea of the DRC as regards the compatibility of this submission with the Constitutive Act of the African Union and the origin of the sources mobilized by the DRC to support its application. Rwanda has talked about a number of legal provisions that all refer to Article 56 of the African Charter in order to reboot the reservability, the admissibility of this application, which are not founded and not grounded, as I will explain it later on. Rwanda seems to ignore that this article excludes explicitly the interstate applications, insofar as that any other application or applications or rules referring to this article in the matter should be considered as non-admissible when it comes to such applications. It is Article 6 of the Protocol of establishing this court, and Rule 50 of the rule which Rwanda refers to. You would see that Rwanda is using confused arguments, and they are inconsistent in developing their arguments. The pleading of Evongin Machar has underlined this confusion in the reasoning of Rwanda. I would like to start to explain such means used by Rwanda, especially the incompatibility of with the Charter and the African Union Constitutive Act, and I'll come back to the argument used regarding to the origin of the sources mobilized by the DRC to support its application. Honorable Vice President, Honorable Justices, I would start with the first point relating to the so-called incompatibility of the application with the Constitutive Act of the African Union and the African Charter of the Human and People's Rights. Rwanda alleges that grave and massive violation of human rights perpetrated and that they continue to perpetrate in Congo would constitute issues of peace and security, and therefore political issues that should not be examined by this court. The representatives have mentioned it yesterday and today too during their submissions. Allow me to indicate that by raising such an objection, Rwanda is making a confusion between the issues of jurisdiction and the admissibility. The argument used by Rwanda consists in saying that the application of the DRC should be considered by the African Union, not by this court. The arguments are artificial insofar as Rwanda has not demonstrated with accuracy what violation human rights invoked by the DRC would constitute political issues that will relate to the relevant organs of the African Union, that is to say the conference and the Peace and Security Council of the African Union. Rwanda forgets that the notion of peace and security has been determined, should be determined in its substance and form. They have not indicated their legal meaning, and to what extent the violation of the human rights invoked by the DRC would be part of issues under this purview, which make us doubt on the credibility of the argument used. Mr. Honorable Vice President, Honorable Judges, how the violation of the right to life and physical integrity invoked by the DRC in its application could constitute reasonably an issue of political or peace and security issue, and therefore escape to your consideration. On the other hand, the debate on the legal nature and political nature of the issues submitted to the consideration of the national jurisdiction has become today not relevant. They have only a historical value. But if you have to come back to them to justify this code, the DRC would like to underline that the international jurisdiction admits that legal issues are the ones that pose issues of law, and for which a jurisdiction is called to make interpretation and implement the principle of legal rules. This is an extract from the International Court of Justice in the case of Western Sahara, para 15. Based on these references, the International Court of Justice has estimated that the court cannot not answer to legal elements for a question, whatever be the political aspects, to undertake a judicial mission, that is to say, the appreciation of this case under the international law. This is put under the paragraph about the conformity with international law, and the case relating to Kosovo, paragraph 27. Moreover, Rwanda has visibly a very limited conception of peace and security. They forget that to date there is a relationship between peace and security and human rights violation. The position they defend in this prospect suggests that any application on violation of human rights committed in an armed conflict context, such as the one waged by Rwanda in the DRC, should be declared inadmissible. At the same time, and paradoxically, by responding yesterday to the question of one of the honorable judges on this issue, the lead counsel of Rwanda answered that the dimension of human rights is not included in this case, but that the case would relate not only, not exclusively, but essentially on political issues. Semantically, if we situate these words semantically, we have nevertheless to draw the legal meaning of such words. However, the danger of the argument of Rwanda, if the court declares the admissibility, the court will be deprived of its competence based on the violation of human rights, since there is a relationship between peace and with them and peace and security, which will deprive your court from its relevance in this context of the African continent, which knows grave violation of human rights, such as the ones perpetrated on the Congolese territory. Mr. Vice President, after this contextual arguments, I would like now to talk about the relationship with the African Union Charter, especially regarding the jurisprudence of this court. Regarding the case Abubakar versus Tanzania, it concluded that what is important for a case to be compatible with the Constitution of the African Union and the Charter is that in their substance regarding the violation, they should be able to be considered in reference to provisions of the Constitutive Act or the Charter, and should not come manifestly outside the scope of these articles. It is under paragraph 50. The respondent state cannot contest the fact that the case submitted, which is or rather talks about grievances that deal with the grave and massive violation of human rights perpetrated by Rwanda on the Congolese territory, and that the applicant state is requesting your state, and this is included in paragraph 124 of this judgment. And in the case Alex Toma versus Tanzania, the objective of the African Union is to promote and protect human rights and people's rights in Africa. This protection should go through the strengthening of the mechanism relating to this objective. Also, it has to go to get along with the adoption of appropriate measures to guarantee the respect of human rights. Therefore, the DRC is requesting the court to indicate that Rwanda has perpetrated human rights violation, and that it will take measures in implementation of the international law. The compatibility in this at this level is not enough. like in Alex Toma case, you have just to say that there are facts relating to human rights violation protected by the Charter, and this is in paragraph 56 of this Charter. The prima facie appears when it was concluded that the application should show a prima facie violation of human rights as protected by the Charter. The court would note indeed that the application of the DRC fulfills all these requirements, legal requirements. So, as indicated yesterday by Professor Lumba, there is no doubt regarding the legal fulfillment of all the requirements and also the violation of Rwanda of human rights. Honorable Vice President, Honorable Justices, now I am going to tackle the last item, which is the origin of the sources mobilized by the DRC. I will tackle it under two angles, and I would like to mention the contradictions in the pleadings of Rwanda, and also by restituting the scope of the requirements of the origin of the sources in order to show that the application of the DRC is not exclusively based on mass media communication only. In its inadmissibility objection, Rwanda says that we are basing ourselves on mass media articles, while they say that a careful scrutiny can be used as evidence of allegation of human rights violation in the region. Indeed, Rwanda is entertaining deliberately a confusion between issues of exclusivity of the origin of the sources coming from mass media, which relate to the admissibility of the application, and that relating to the production of evidence to support an application that should be analyzed as regards its its merit, and at this stage it is not useful to mention the issue of evidence regarding to human rights violation. The analysis of the jurisprudence of the court shows that this requirement aims not the quality of the sources, which means the consideration of the evidence, but rather to the mass media nature. So, in fact, they want to forbid the spreading of information through the mass media. So, but it does not prevent from the possibility to mobilize such information with the means coming from other sources. In other words, Honorable Vice President, this requirement is not founded on exclusion criteria, but rather exclusivity of information drawn from mass communication means. The African Commission has admitted this interpretation. It's Communication 141 and the number 1449 in the case Dauda Diawara versus Gambia, when it asserts, I quote, while it is not relevant to rely only on mass media communication, it is not advisable to dismiss a communication because some aspects are based on information disseminated by mass communication. And this comes from the fact that the Charter is using the expression exclusively. It has also indicated, and I quote, that no doubt that mass media communication remain the most important source of information. We all know that information on human rights comes also from communication, mass media communication. And what is even more interesting is that the Commission indicates and talks about the genocide and says that genocide in Rwanda has been disseminated by mass media communication. So the question here is to know how Rwanda, which allegations of genocide were founded on news disseminated by communication means, will dismiss accusation of human rights violation on the Congolese territory because they are based on such sources, and this is an additional evidence of the pragmatic self-destruction of the arguments as mentioned yesterday by the agents of the DRC before your court. At any rate, the DRC has produced some elements that show that it doesn't rely only on communication communicated by mass media. The elements mobilized by the DRC do not come exclusively from such sources, but rather they're trying to extend the scope of this requirement, saying that it should not be interpreted by referring only to articles, press articles, but rather it should include information based on these sources. Honorable President, honorable judges, it seems that the real objective of Rwanda is to question and challenge, as usual, the relevance and the credibility of some official sources, such as the one of the United Nations, the African Union, and NGOs that show its responsibility in the violation of human rights perpetrated in the DRC. In Rwanda, even they talk about the military captured in the battlefield in the Congolese territory, referred to yesterday by the professor, and the presence of its defense forces, which are now in Goma and Vigo, denounced by the RC and disseminated by the media